So welcome to the Mediators New Breakfast Club. And in a minute, we'll introduce David Steward and Clive Aston, our distinguished contributors. This is being recorded, as you will have seen, and the recording will be made available online later in the usual way once it's been edited. So, Dave, over to you. Sorry. Our first attendees, and please feel free to use the chat facility, and there will be an opportunity for Q&A towards the end, and we'll also be announcing the save the date for our next meeting in January. So, Dave, over to you. Where's he gone? Dave, you might be on mute.
Sorry about that.
Over to you.
We've got about 11 first timers. So if you're happy to, please introduce yourself. I'll call your name by surname in alphabetical order. So if you can just mention who you are, maybe where you are, and your interest in mediation. The first person I've got is Salma Ben Ayed. Are you there, Salma?
Hi, good morning. Yes, I'm Salma Ben Ayed. I'm doctor in private law. I'm from Tunisia. I'm passionate about AGR since 3 years ago. So I'm trying to practice it and to get the training every day. So thank you for this opportunity.
Thank you very much. Next, I've got Stephanie. Stephanie, I'm going to get this wrong. Blankestige. Are you there, Stephanie? Okay, I'll come back in a second then, maybe. Terry Brooks, I think you're a first timer still. Are you there?
Good morning. Yes, I am here. How are you?
Yeah, I'm well, thanks. Could you just mention your interest in mediation and maybe where you're speaking from today?
Yep. Sorry, just make sure the camera's on. So my name's Terry Brooks. I've got a small community interest company which does legal advice, mediation and training. But I'm trying to come out of the legal sector a bit and go further into mediation. I qualified in civil and commercial mediation back in, I think, around about May time. And then I did workplace mediation a little bit later, around about June, July time. So at the moment, I'm just kind of trying to get as many points as I can to be CMC registered and to build up my experience and obviously learn from people like yourselves that are far more experienced than me and learn the do's and don'ts of mediation and hopefully build up my business.
Thanks so much, Terry. And I've next got Martin Ellis, if you're there, please. Are you there, Martin? Then I'll go on to Giselle Green.
Yes,
Giselle, are you there?
Yes, I'm there. Hi there, everyone. I'm Giselle. I'm based in London. I'm a former BBC radio news journalist and producer. I've worked in political and charity comms and done training for journalists. And I'm now just recently done the training at the London School of Mediation in civil and commercial, and I'm looking to start getting some experience as an observer and a co-mediator and volunteering my services in community mediation.
Thanks, Giselle. Next, I've got Trevor Harrison. Are you there, Trevor?
I am. Yes, good morning. I've only just arrived. I'm a maritime arbitrator and I've been mediating, well, I trained about 20 years ago. So that's probably enough to be going on with.
Okay, thank you. Richard Hills.
Good morning.
Good morning.
Richard Hills. I'm in the West End. My main business started up in 1992 as a Japanese restaurant, which is just down the road from me here. And then as the restaurant got more and more established after nearly 30 years. I started in 2014 mediation. I've been doing community and workplace mediation since then.
Thank you. Bill Holohan.
Hello, I'm an Irish solicitor and senior counsel. I describe myself as a lawyer who, having worshipped in the Satanic Church of litigation for 25 years, converted to the one true church of mediation about 15 or 16 years ago. And I am a former chair of the Chartered Institute of Arbitrators Irish branch, director of the Mediators Institute in Ireland. So I practice a lot in the area of mediation.
Thank you. Claudine Howell, are you with us? Okay, I'll move on. Cara Naran, are you there, please? No. Kathy O'Mahony. Kathy, are you there? Not yet. Claudine Pelzer. Claudine, are you there?
Yes, good morning. As you can see, I'm in uniform still. I've served in the British Army for 21 years now. Work with vulnerable families and work in safeguarding, protecting soldiers, their spouses and children. So just qualified recently in commercial mediation and also workplace. My next venture is SDN world of mediation. And yes, very much like a lot of the people who've introduced themselves and wanting to gain experience. I've joined some CPD groups as well and other panels. And yes, good morning to everybody.
Thank you. Joe Ray. Joe, are you there? No. Are there any other first-timers who haven't yet spoken?
Yes, good morning, Dave. Maxine.
Morning. Oh, Maxine, hi, sorry.
Okay.
Sorry, I hadn't got an asterisk next to your name. Welcome.
Okay. Good morning. Thank you, Dave. Good morning, all. You heard my name just now. I sit in the County of Surrey, in London. Did my mediation course in March of this year. And so wonderful to have attended the International Mediation Week last week. Met Dave and got introduction, well, told about today's meeting. So I'm looking forward to what I can kind of achieve and better understand. And yes, my bit is I haven't started practicing mediation. Did it in civil and commercial. My specialism is in family law. And so that's where I'll be looking to get some co-mediation experience and to build my patience to kind of go on, or my confidence rather, to then go on and start doing mediation work with the family courts. Thanks
very much. Any other first timers?
Yes, hi.
Hi, Stephanie.
Hi,
I did announce you, but I wasn't sure about how to pronounce your surname.
Don't worry, it's Blankenstein. So yeah, I'm originally from the Netherlands, now living in London, where I qualified and worked as a lawyer, specialized in employment law. And I moved to London in 2005, did all sorts of things. My last, what I'm working at the moment is as a consultant for an organizer that organizes specialized legal events. I have qualified for civil and commercial mediation and workplace mediation. I haven't started work as a mediator yet, but looking at experience, observations, co-mediations. And yeah, I'm really thrilled to be here. Thank you for inviting me. Welcome, everybody, and looking forward to the talk.
Thank you. Last call for any other first timers.
I'm new.
Right.
Hello, Rhea Stevens. I'm from the United States, as the accent probably gives away. I got my Juris Doctorate about almost 30 years ago. A few years ago, I transitioned my practice to exclusively mediations and arbitrations. I do anything from family law to health law. I'm credentialed through a number of different organizations, including FINRA, and I just love it. I really am very passionate about ADR currently actually in Manchester, obtaining an LLM in mediation and ADR.
Thank you very much. Anybody else?
Okay, Dave, should we move on? That's
yeah,
great. Thank you, everybody, for introducing.
Thank you.
Thank you, Dave. It's my pleasure to introduce Clive Aston and David Steward, both extremely experienced maritime arbitrators, and David is the current president of the London Maritime Arbitration Association. And Clive is a past president and has been involved in various mediation initiatives in the maritime world. So really over to them. We'll have some Q&A at the end. Martin, our clerk, who's organizing this from a technical point of view, is currently in Dubai at the Dubai International Arbitration Week, and we may invite him at the end to say something about mediation initiatives over there. So David and Clive, the floor is yours.
Thank you, Michael. Thank you, Dave, and thank you, Martin, for setting up the Zoom session. A very good morning to everybody. Our title, London Maritime Dispute Resolution, applies not just to arbitration, but also to dispute resolution more widely, including mediation, a cornerstone of the UK's strength in maritime law and trade. That title is taken from a recent report by a consultancy called Oxera. And the report was commissioned by Legal UK, whose role is to promote English law for international business. And it reflects London's position as the primary seat of choice for international maritime dispute resolution. In doing so, it cites a report by the City of London Corporation, which I'll just briefly quote from. It says, use of English law and UK arbitration internationally for maritime business is a cornerstone of the UK's strength in maritime law. And from that, Oxera say, although other maritime hubs will have some expertise in English law, the UK is at a major advantage thanks to the number of legal practitioners and the depth of existing expertise. And we believe that that's really central to London's position for maritime arbitration. Over many years, we've built up a body of expertise. We have solicitors, barristers, expert witnesses, marine engineers, naval architects, all kinds of people who have experience in dispute resolution and are available to participate in these references. So against that background, we'll just whiz you through a history of the organization and background to the LMAA and the practice of resolving maritime disputes in arbitration in London. So brief history of the LMAA. Well, we can't claim to have invented maritime dispute resolution in London. The Athenian orator Demosthenes wrote about parties referring a shipping dispute to an arbitrator in the 4th century BC, and there is no truth in the rumor that they're still waiting for the award. But there is a long-standing tradition of maritime arbitration by commercial people in London. And the roots of our association, the LMAA, although it's a relatively new creation, its roots reach back more than 300 years over the history of the Baltic Exchange. So a little bit about the Baltic. Prior to 1744, the Virginia Coffee House in Threadneedle Street in the city was a place where merchants traded goods from America. Then the Virginia and Baltic Coffee House was established, and the addition of the word Baltic reflected the growing importance of the Baltic Sea market in commodities. By the early 19th century, it had moved to new premises and it had expanded beyond what could be accommodated in a coffee house. And there was a growing concern at that time among traders that the market was unregulated with speculation and unacceptable practices. So that really became the Baltic's role. In the 1910s, the new Baltic Mercantile and Shipping Exchange opened with 1,400 members. And by 1914, there were nearly 2,500 members. And over time, the practice grew of arbitrations being conducted, often informally, between members of the shipbroking fraternity. So disputes would be put to brokers on the floor of the Baltic and resolved in a relatively informal way. Now, the LMAA was founded in 1960 at a meeting of the arbitrators of the Baltic Exchange approved list. And since then, our full membership has expanded so that the list of practicing arbitrators now embraces a variety of disciplines, not just brokers, but former solicitors and barristers, some people who've worked in P&I clubs, or people who've worked in companies engaged in shipping, and also marine engineers and naval architects and ship surveyors and so on. We're not an institution, we're an association of practicing maritime arbitrators, so very different from the ICC and the LCIA, but we'll comment a little bit on the significance of that later. The association originally consisted only of full members, but in 1972, we introduced the idea of supporting membership. Supporting members are people who are in sympathy with and lend their support to the objects of the association. Some, but not all of them, accept appointments as arbitrators. A lot of supporting members are essentially users of LMAA arbitration, including solicitors in private practice and claims handlers in P&I clubs. For those who are not familiar with protection and indemnity clubs, they're essentially insurers of the liabilities of ship owners. So the category of aspiring full membership was established in 2010, and aspiring full members have met certain of the requirements for full membership, but are still looking for more LMAA appointments in order to meet all the criteria. But the important point is that those three lists of members, when you take them together, drawn from specialists involved in many services connected with shipping and maritime arbitration, show the diversity of our membership overall. We've got people from a range of disciplines, a range of ethnic backgrounds and genders. Now, the really important thing for us is competence. The LMAA Advice on Ethics, which we publish on our website, emphasizes that to be competent, an arbitrator should have knowledge and experience of the matters in dispute, for them not to require an unduly long explanation every time they come into an arbitration. So there's no learning curve. And they've also got to know enough about the law and procedure of arbitration to be able to conduct the proceedings efficiently and to write a clear and enforceable award. And there are a number of reasons why this is really important. There used to be, until 1979, an unpopular and discredited procedure for judicial review of arbitration called the special case. And it was quite often open to abuse because the losing party would demand that a special case be stated and put to the court on a whole series of points in the arbitration. But that was abolished by the Arbitration Act 1979. And what we now have is a much more limited opportunity to apply for permission to appeal to the court, and only on questions of law. So it's very important that our arbitrators have the skill and expertise to get things right, particularly because the 1996 Act places responsibility on the tribunal to adopt suitable procedures with a view to avoiding unnecessary delay and expense. So the tribunal, subject to the Act and subject to our terms, are deciding all procedural and evidential matters. So you can see that the association has blossomed over the years from a tiny group of Baltic brokers to an organization with almost 40 full members, several hundred supporting members, and a full-time executive secretary. The competition has changed over the years. We used to get a lot of competition from New York and Paris. That's diminished substantially. Although some other centers, particularly in Asia, are developing, it's still the case that London does 80 or 90% of the world's maritime arbitration. So just a very quick look to put that into context at the latest stats. We review our statistics annually. So the most recent stats we have are for 2020. And we estimate that there were in 2020 on LMAA terms and procedures, 1,775 references, which, bearing in mind that there would have been more than one arbitrator in a number of those cases, equates to something over 3,000 appointments on LMAA terms and procedures. And we estimate that there were about 523 awards issued on those terms during 2020. Now, without going into a lot of detail of how other associations and institutions were doing at that time, we're way ahead. Nobody's even close to those sort of statistics. So what I'm going to do now is, having sort of set the scene like that, is hand over to Clive to talk a little bit about how maritime arbitration has changed over the years.
Thank you, David. Well, as David has described, in the early years of the association, most of the arbitrators were practicing shipping people, brokers. People always say that before the Lmaa, arbitration would take the form of a quick meeting, perhaps over a drink with the parties and a broker. The broker would go off, think about it, and then they'd meet up for lunch, and the broker would tell them who he thought had the best argument, and whoever lost would pay for the lunch. That was really, things weren't too far apart from that when the Lmaa started. There was certainly a lot less formality than there is nowadays. And I think that reflected the fact that all of the parties involved in the process were usually commercial people. It was only really in the larger cases that you would see the lawyers become involved. In those days, written submissions came to be the order of the day, but they were fairly brief and informal, often written by commercial people in fairly simple, straightforward language. And that there weren't great bundles of documents in support of the arguments. And after those written submissions had been exchanged, then each party having appointed their arbitrator, the arbitrators would meet up over lunch, usually at the Baltic Exchange. And you'll hear a lot that in the early days, drinks seemed to play quite a large role in the dispute resolution process. And many would say perhaps it would be better if it did nowadays. I don't know about that. But the arbitrators would meet, they would decide what they thought the right result was, and one of them would write the award. If they couldn't agree, then they would bring in an umpire to act as the third and deciding arbitrator in the process. Now, the awards that they wrote were pretty short and to the point. The intention was that, as in all arbitrations, they were confidential and no use was going to be made of them in any other process. The exception to that was something called the special case, which is a historical procedure where the parties anticipated that the case was important enough to go to court. They'd asked the arbitrators to set out the facts and their reasoning in more detail so that the court had something to get a sense of what had been argued before the arbitrators. But very few cases really went to court. Although having said that, maritime law is a very important foundation of English contract law. And for students of contract law, even in your first year of studying the law, you'll find a lot of shipping cases involved. I think the maritime field has always been quite litigious, and it's certainly been a rich vein for contract lawyers and remains so even now. It was pretty rare for there to be an oral hearing after the 1960s. Most cases, as today, it's 80% now, would be dealt with on documents alone. But where they did have a hearing, that would normally take place at what used to be called the old Baltic Exchange that David has referred to, the broker's home. Sadly, it was blown up in the 80s, but there used to be an arbitration room there that was always used, very much emphasizing the fact that maritime arbitration is a product of and remains a part of the maritime community generally. Now, both David and I were practitioners back in the day, and I'm sure you have some memories of those arbitrations, David.
Well, I do, Clive. I often tell the story of my first ever maritime arbitration, and I see that Jonathan is on the call today, and this will will take him back to the early 80s. I had just begun my articles with a maritime law firm in the city, and maritime arbitration was completely new to me, but I was sitting with one of the senior partners, and he received a dispute under a charter party in relation to a safe port warranty. Very urgent, because the ship was sitting off the port. The master was waiting for instructions from the owners as to whether he could go into the port or not. Now, as soon as the two law firms were instructed, there was cooperation between them. They appointed a sole arbitrator. He was a former chartering broker, and he'd seen this clause or similar clauses plenty of times in the past. He was very familiar with this sort of contract. There were no formal pleadings, some brief written submissions, no disclosure, no witness statements or experts' reports, no barristers instructed. I toddled off down to the arbitrator's office with the partners from the two law firms, and out came the China tea service. And over tea and biscuits, the two solicitors made their brief submissions. The arbitrator gave his decision the same day, and he issued his formal award a day or two later.
Yeah, unfortunately, such cases would be very unlikely to happen now. They might in very exceptional circumstances, but things have moved on. Things are far more complex now. Many people say that arbitration has come to reflect and mirror court proceedings. And I often wonder what the reason for that was, because in these sort of days that we're talking about, the system worked very well. But I think there are a number of reasons for it. I think the parties became more knowledgeable and sophisticated. They sort of, a lot of them, in the early days, a lot of the ship owners were self-made people. They hadn't been to university. They'd always been in the business. In the 70s, a lot of them started sending their children overseas to universities. Those children took over the business, but they did so with perhaps more of an academic or educated background. They looked to demand more from the services that they were buying into. One hears stories of ship owners employing lawyers in the 50s and 60s, and life was really very easy for them. They could often go off and have second jobs, and many of them did by becoming arbitrators. But by the 80s, 90s, and certainly now, ship owners expect their employed lawyers to be available 24 hours a day. And really, they're expecting to absolutely squeeze the most out of them. And I think so it is with arbitration and other dispute resolution fora, that the users are far more demanding. And you couldn't get away as an advisor in saying, well, go for 50-50, because even if statistically that was the result that you should achieve, they were looking for a far more scientific justification for any decision made. So I think that was certainly one of the reasons. Many of these parties were also originally in London, and so able to socialize with arbitrators and other parties. Many of those left London, and that sort of intimacy went with them. And suddenly you were looking at parties who are both outside the UK with very little opportunity of actual interaction with each other, which is often so important, which you as mediators will understand, that physical contact can be very important in resolving disputes. But whilst certainly 80% of cases now are still dealt with on documents alone, they've become far more sophisticated in the submissions. The parties take matters far further than they used to, and they're far more willing to argue, I would say, the extremes of the law, and perhaps even to look at making new law. So arbitration awards have become a lot more complicated than they used to be in the old days. When hearings take place, they're very difficult to how they used to be. And certainly one thing I would emphasize is that arbitration hearings now are totally dry. we're all very conscious, because we all issue reasoned awards, of the possibility, although David has pointed out it's not that often, but the possibility of our awards being scrutinized by the courts. So all of that has sort of seen this move towards far greater formality. David.
Yeah, thank you, Clive. I'm just picking up on one really important point that Clive made about shipping cases being so important to the development of the English common law. You'll probably remember that a lot of English contract cases are based on shipping law, and also tort, the wagon mound and so on. They're all had their origins in shipping disputes. When Lord Thomas was Lord Chief Justice a few years ago, he expressed some concern about whether arbitration was too final, in the sense that too many disputes were being resolved in arbitration and not enough were getting in front of the court, so that we could continue to contribute to the development of the case law by establishing precedents. I have a huge respect for Lord Thomas, and I can see his point. My personal view is that currently the balance is about right. The Arbitration Act allows a party to apply for permission to appeal on a point of law, but generally speaking, my experience is that the commercial judges are not going to give that permission unless they think something has really gone quite wrong with the award. They tend to support the process of arbitration. And of course, the other side of the coin is that commercial parties want finality. They don't want to be, in many cases, to be faced with the prospect of a vista of appeals up to the Supreme Court. So it's a difficult balance, but I think we have to accept that in the interests of commercial finality, some cases are not going to get to court and be considered and turn into precedents. Now, just a brief word on what we mean by maritime, because I think there's a tendency. I spoke to a law firm the other package of arbitrators and terms who dealt mostly with carriage of goods by sea, charter parties and bills of lading. Now, those or is fixed to the seabed. We hear disputes under contracts for the building of ships, drilling rigs, and specialized vessels for the energy industry. And our offshore energy work extends to both oil and gas and renewables. We're seeing an increasing number of disputes under charter parties and construction contracts in the wind farm sector. BIMCO, the Baltic International Maritime Organization, publishes a number of standard form contracts which contain a dispute resolution clause providing for London arbitration on LMAA terms as the default. And those include contracts for the hire of boats in the energy sector, heavy lift contracts, and even decommissioning of offshore installations. In the field of shipping, we're dealing not only with conventional cargo vessels, but we're increasingly seeing disputes involving the building, sale, and chartering of super yachts, for example. And of course, we also handle disputes involving international trade, the sale, purchase, financing, and carriage of commodities. Now, Clive, would you like to just talk briefly about the fact that we are not an institution?
I will. I'll deal with it quite briefly, because I can see quite a lot of interesting points coming up on the chat line. David mentioned the fact that we're not an institution, and the broad distinction that we're looking at here is between what's called institutional arbitration and what we practice, which is ad hoc arbitration. Institutional arbitration is arbitration administered by an organization, such as, for example, the ICC, the London Court of International Arbitration, and a number of other bodies. They take on the role of basically the administrators of the arbitration. They are involved in drafting the terms of reference, the appointment of the tribunal, and thereafter the supervision of everything that the tribunal does and finally the review of draft awards before they're published. Ad hoc arbitration is totally different in the sense that the LMAA is really no more than a central office for the Association of Independent Arbitrators. It is, as David said, just one person, and the administrative roles that they have so far as affects parties to a dispute is very, very minimal. There are some cases where if parties can't agree on the identity of an arbitrator, the association or the president will make an appointment, but that is relatively a small percentage of the overall cases. Basically, we all individually administer the arbitrations in which we're appointed. And what that means in practical terms is that there is no outside level of expense. The expense is purely that of the individual arbitrators. In institutional arbitration, you'll often see that the costs of the institute are as much as, if not more, than those of the arbitrators themselves. And I think one of the reasons the maritime community has focused on ad hoc arbitration is that they've become very used to the ease of doing things. If you want to appoint an arbitrator, it can be done simply by sending an email to the arbitrator. The arbitrator will respond to accept, and then notice of that can be sent by the claimant to the other party with the requirement that they then appoint their arbitrator. In institutional arbitration, the process is really quite long-winded and can often take 3 or 4 months, and may end up with arbitrators being appointed who are either not expert in the field, but certainly may not necessarily be known to the parties or the choice of the parties. So in that way, ad hoc, when you hear of ad hoc arbitration, you're talking of far less administrative baggage. And also, I think, far less formality involved. The other point that I think David is going to briefly come on to is that with ad hoc arbitration, although we are all individuals, we work on the basis of LMAA terms, which are very well known in the market, but have been designed over time with a view to simplicity and ease of use by users really from all over the world. David.
Yeah, thank you, Clive. I wonder whether, given how time is pressing on, and given how we, as you say, Clive, we've got some very interesting questions coming up in the chat. I wonder if we might cut to the chase a little bit. And if I just mention briefly the position in relation to our terms, Clive, do you think we might then pick up on some of the questions in the chat window?
We might just briefly say where we think things are going.
Yes, good idea. Okay, let me just briefly talk about terms. We have a main set of terms, which were most recently revised this year, and the latest version, the 2021 version, was issued on the 1st of May. I think the important thing about that is that I quite often hear people, particularly in the offshore oil and gas industry, saying that the reason they choose institutions is because they don't just want to rely on the Arbitration Act 1996, they want more of a structure. Well, my view is that the LMAA terms provide an extremely good structure. And as Clive says, although we all practice as individual arbitrators, we all operate on those terms. So there is a degree of consistency. There are powers given to us. There's guidance as to how the references should be conducted. So I think that's important. We also have, alongside those terms, 2 streamlined procedures, one which we call the small claims procedure, which nowadays I think tends to be used for disputes below $100,000. And that is generally a documents only procedure. And it has very tight timetables and tight restrictions on word count and so on. And it works very efficiently. And most importantly, the LMAA does not charge a fee for that. The fee of £4,000, which encompasses everything up to and including the award, goes to the arbitrator. The only time we get involved is if the parties can't agree on the arbitrator, and then there's a nominal fee for the president appointing an arbitrator. And then we also have the intermediate claims procedure, which is for somewhat larger claims. And that too is a streamlined procedure with some tight timetables for the parties and also for the issue of the award. Having said that, Clive, would you like to just round things off a little bit by talking about where you see the future?
Yes, indeed. We've obviously talked a lot about the past and how we've got to where we are today. And what I wouldn't want to leave the impression is that we're a load of fuddy-duddies who sort of hark back to the days where we could have port after a long lunch at the Baltic, which isn't the case at all. One can never go back, and nostalgia is a nice indulgence, but not really much use. And for some time, I think because of the fact that arbitration has started to reflect court procedures, there has been this wish on the part of users to go back and bear in mind the original attraction of arbitration, which is confidentiality, speed, expertise in the field, and reasonable cost. And we change our terms every 5 years. And the last few sets of terms have all really been geared towards trying to get back so far as one can to those core values. And introducing procedures that can help parties achieve that. And I think in some way we feel we've been quite successful, because in the late 80s, 90s, one would be looking at the life of a case being 2 to 3 years quite easily. And I think we would start to be embarrassed now if a case took very much more than a year from start to finish. But looking forward, it's all very well, I think, for users to say they want things to be quicker and cheaper. But the reality is that when it gets to a dispute itself, those self-same parties take a lot of persuasion to follow their philosophy. And I think that I certainly foresee the need in arbitration in the future for far greater proactivity on the part of tribunals. I think you will see arbitrators having to get more involved in pushing parties to streamline procedures. If you say to a party, do you want to take the shortcut or do you want to do it the long route? More often than not, you'll find that the parties say we want to do it the long route. And so I think you will see that there will be a need for arbitrators to be given, or to give ourselves stricter powers to say to the parties, really, it's in everyone's best interests for you to take the shortcut, and it's not going to prejudice your rights or your interests in any way. And I think sort of reflecting this, and partly because the LMAA recognises that arbitration is not the only show in town, we will in the new year be launching an early neutral evaluation scheme that will enable parties to get the guidance, albeit on a non-binding basis, of arbitrators on the merits of disputes in a way that will enable them, hopefully, to embark on constructive settlement discussions and avoid the need to go all the way in every case to an arbitration award. And that will sit alongside newly established dispute board resolution for the larger project cases in the maritime field. Closer to home in the context of this morning, we also have and always have had a maritime offering, and we will certainly be looking at that. We feel that people perhaps felt that the skill sets of arbitrators were too different to those of mediators in order to make arbitrators suitable candidates as mediators. I think the feeling we have is that whilst in some instances that may certainly be the case, that arbitrators may be used to stating their view and perhaps not so good at bringing the parties to evaluate their own cases, that there are certainly enough of us to provide a suitable offering for mediation services in the future. David.
Yeah, thank you very much, Clive. I'd like to start picking up on some of these excellent questions. Ria has asked, if the umpire doesn't come in until the end, does that person really have a feel for the whole case? Subject to Clive's recent experiences, I very, very rarely see umpires appointed now. We tend to have tribunals of either 1 or 3 arbitrators. But just to explain the background to this, the procedure where you have an umpire is that if there's disagreement between two party-appointed arbitrators, the umpire comes in and the two arbitrators drop out and the umpire decides the case. And that can be, the traditional problem with that was that it could be cumbersome and costly because the umpire would have to start from scratch all over again. And in fact, a practice developed of of an umpire being appointed at an early stage in case he was needed, and then invited to sit in on the deliberation, the hearing and the deliberations by the two arbitrators. Well, that's all very cumbersome. And what we find much more now, and in fact, what the Lmaa terms contemplate, is that if you don't have a sole arbitrator, you have a tribunal of three. And we have a mechanism for the two party-appointed arbitrators to be able to minimize costs by deferring the appointment of the third. They don't have to appoint the third immediately. The third will be appointed if the two disagree or if you're getting close to a hearing or an award that requires all three to be involved. But I think the answer to Ria's question is when the third arbitrator comes in, no, I don't think they're at a disadvantage. Because in that situation, the two party-appointed arbitrators remain on the tribunal, and so they've got a full knowledge of the history of the case. And actually, the whole point about our arbitrators being experienced and knowledgeable is that they can pick these things up pretty quickly. So short answer is I think we rarely see umpires now, and I don't think there's a disadvantage for a third arbitrator coming in. And then perhaps Clive and I can share Liz's question about
yes,
virtual hearings, Zoom hearings. I was just going to preface that, Clive, by saying that there's a lot of talk at the moment about sustainability in arbitration, and the Lmaa has been conducting what you might call sustainable arbitration for a very long time. I can't claim that environmental considerations were the original driver for that. It was much more economic. But a lot of our disputes, as Clive said, are resolved on documents alone. And we've had for a long time a practice of receiving witness evidence remotely by video link and so on. And in fact, a few years ago, I even had an arbitration where there were two US law firms involved, one in New Orleans and one in New York. And instead of flying them over to make submissions in London, the tribunal sat in London and we did the whole thing over Skype. But having sort of set that background, let me just hand over to Clive to talk a little bit about that.
Well, the point that Liz makes is with Zoom, does that mean that there will be more work coming into London, or does it mean that other centres will set up? I think the answer to that is that it may not make too much of a difference in terms of choice of seat, Liz. What often determines the choice of seat is the fact that it's the procedural law of the country where the seat is. And one of the reasons that people choose London as the seat of the arbitration, as well as the advantages that David has said, and one isn't looking to blow the Lmaa trumpet, but we're fairly unique in the UK in having a limited right of appeal from arbitration awards. Most other countries, in fact, almost all, I would say, countries that have any arbitration practice to talk of, do not have a right of appeal from awards. And although it's not commonly used, I think it is perceived by parties as being an advantage for those few cases, and we're not just talking here about maritime, but those few cases where things may go wrong, or where there is such an important question of law that it's felt that the court's view on an award may be needed. So I think Zoom is fairly equal. Although London was very quick off the mark to get protocols for virtual hearings, most of the established arbitration centres have now set up protocols of their own. And so I think that it's no longer an advantage that one country can sort of state that we do virtual hearings and nobody else does. So I think it's fairly neutral. I think there are certainly advantages. I've had cases where witnesses have been flown over from South America for a hearing, only to give 15 minutes evidence, look completely startled, and then be sent back to their country. And the great advantage of Zoom and virtual and hybrid hearings now is that those people can give evidence online or virtually. And so hopefully we can focus on the advantages of that. We're now moving back to the point of hybrid hearings where you have the legal representatives of the parties and tribunal present and the major witnesses with perhaps the less important witnesses giving evidence virtually. And I think that that's the important thing that we will carry forward with us, but I don't think it will either bring or diminish the work that comes to London.
I agree with that, Clive. Thank you. Salma, thank you for your question. Salma asks about the difficulties of arbitration awards in international trade contracts where local jurisdictions don't always accept the validity of arbitration. And that, I suppose, is a problem in relation to enforcement of a London arbitration award against assets in that country. I mean, I think, subject to Clive's views, I would have to defer to lawyers in those jurisdictions or who have experience of those jurisdictions, because, of course, as arbitrators, we don't necessarily get involved in the detail of those considerations. Our role, once we're appointed, is to ensure that we produce an award that is that meets the requirements to be enforceable. And the only other point I'd make is that one of the advantages of arbitration over court proceedings in many instances is the existence of the New York Convention. There are many countries that subscribe to that convention, which provides for ease of enforcement of arbitration awards. But Clive, is there anything you'd like to add to that?
No, I agree entirely with what you said, David.
Yeah, so Salma, I'm sorry we can't really take that much further, but I understand that it can be an issue. Jonathan has his hand up, apparently. Jonathan?
David, thank you, and thank you for bringing back some early memories. Most of I would guess most of those on this call are mediators and many non-maritime. Now, traditional mediation training has it that subject matter knowledge is not essential. If you have a good mediator, he or she can mediate any dispute. There are others who think differently. Earlier this year, I did an RICS mediation training course where they advocate evaluative mediation. I mean, doesn't go all the way, but it goes quite a long way to what we'd call evaluative mediation. So my question, in short, is there a need for specialist maritime mediators? In other words, those who mediate maritime disputes, should they have subject matter knowledge?
Clive?
My own feeling, and I mean, by way of background, when I was on the committee the first time, about 25 years ago, I introduced the mediation terms. And my feeling then and since then has been that it is preferable to have expertise in the field in which one mediates. And I mentioned earlier the fact that maritime users are particularly demanding in their requirements. And I think the idea that a mediator, well, I think a mediator in the maritime field has to command respect from the outset. And I think one of the ways in which they demand and obtain respect is by being known to have knowledge and expertise in the field. I don't feel that if one is looking to promote mediation in the maritime field, that one should do it on the basis that the Archdeacon of York is a qualified mediator and he's going to deal with your demurrage claim or whatever it may be. I also feel that another reason for expertise in the field is that I do foresee I hear the criticism of mediation that it is becoming an expensive operation. Decision makers have to go to usually London, where the mediation takes place. It's very difficult for them to make the time. It's been quite difficult, blah, blah, blah. And in the last sort of year or so, we've obviously seen the development of online mediation. And I know that you, Jonathan, have done your fair share of those. But I think it's even more important whether you're doing online mediation or what, when we drafted the Lmaa terms, we called at the time fax and phone mediations, that from the beginning, the mediator has the confidence of the users. And it's, as I mentioned earlier, when you're not meeting in person, it takes a little bit longer to sort of feel at ease and confident with people. And so where it's all being done online, I think it's even more important that from the beginning, the parties say this is a mediator who knows his or her stuff and also is not going to take a load of, sort of basically a load of bull and not see through it. So very strongly in my personal view that when we look to relaunch our mediation initiative, it will be with people who have maritime expertise.
Thanks.
Right, shall we?
Do you agree, Jonathan?
I do, as it happens. I think it's fundamentally a question of confidence. Well, there are several facets, of course. You don't need to educate the mediator on what is demurrage or lay time or whatever the issue may be. But fundamentally, I think confidence. And I think you're right to stress that that's even more important when it's happening online.
Thank you.
As it's bound to, I think, sorry, just on that point, that even once COVID, we all pray, is finally someday behind us, I think because of things like the Green Pledge, many of the mediators here will be aware of the Green Pledge for mediation. And many of us have signed up to that, which I think carries with it the notion that really online mediation should perhaps be the default option. Pre-lockdown, it wasn't so unusual to have a party flying from Beijing, another party flying from New York for perhaps a 1 or 2 day hearing mediation in London. I mean, that was crazy in sustainability terms. So I think that we're going to see a lot less of that in the future.
That's very interesting.
David, do you want to pick up any more questions?
I think I've picked up everything I can see, other than the fact that we appear to owe the Archdeacon of York an apology because it's a woman, not a man. And I'm suitably contrite. But there is, I wonder if, given that we're getting to 10 o'clock, should I hand back to you and Dave, Michael?
Well, thank you, David. Yes, I was just going to, is there anybody else who'd like to ask a question? Just put your hand up and see if you'd like to ask a question. Anybody else? Any more?
Michael, sorry to interrupt, but I've just noticed that at the bottom of my screen, Salma has asked one more question about security issues and breach of confidentiality when the whole session is done virtually. I think I can respond quite briefly to that. You're quite right to raise it, Salma. It is a concern, but the LMAA, most of our virtual arbitrations are conducted with the assistance of organizations such as the International Dispute Resolution Center, and they have various security protocols and so on. And so I think the risk of security breaches, certainly in the context of our arbitrations, is very small.
We have a hand up. I see we have a hand up, Michael, from McDonald.
Okay.
Yes. Thank you so very much for your presentations. That was very, very insightful. My question is, having recognized that expert knowledge of maritime law may be necessary for those that want to be involved in maritime mediation, do you consider running trainings that will be both on the subject matter of maritime law as well as on mediation, so that your future mediators may have the necessary expertise in maritime law while mediating maritime disputes? Thank you.
Clive, do you want to pick that one up?
So the point, MacDonald, was what, that the knowledge in the field of maritime.
Well, you mentioned that from your point of view,
yeah,
it is important that any mediator that wants to mediate maritime disputes have maritime expertise.
Yeah.
And you also have said that there are terms that has to do with facts and full mediation in their new terms in Lmaa. So I'm just asking whether you are considering the prospect of giving trainings to future mediators of Lmaa that don't have maritime knowledge, or are you just operating on the assumption that all the people that are going to be mediators of your association will always be people that have maritime experts?
I see the point you're making. I mean, an important point is that the Lmaa makes up, on the arbitration side, as full members, people who already have knowledge and experience in the area. We are not in the business of training people to give them maritime knowledge. What we occasionally find is that people with maritime knowledge come to us and seek our help and guidance in gaining arbitration knowledge and experience. So it works that way, that the basic knowledge of maritime is there, and we try to encourage people to gain the arbitration experience. In the mediation field, I think it would probably, so far as Lmaa mediators or Lmaa panel of mediators in the future is concerned, it will be the same, that we will expect people to have that basic maritime knowledge and then to use that knowledge as Lmaa sort of panel mediators. So we won't be saying to the Archdeacon of York, we're going to give you a course in maritime. That knowledge has to be there first.
But in fact, it'd be fair to say, Clive, wouldn't it, that there are various academic institutions that offer, postgraduate qualifications in maritime law, and indeed, there are some of the institutions that actually are offering. I think there's a joint CIARB and somebody else course which is coming up fairly soon, where people can actually gain knowledge in maritime law. So that stuff is available kind of separately, I guess, is the way to put it, and it's worth looking around if you want to go that way.
Absolutely.
Thank you. Well, unless anybody's, are there any other hands up, Martin, that we can see? Okay, well, it remains, I was just going to start, just wrap up by thanking David and Clive so much for their time and coming along to talk to us this morning. When I was first involved in both mediation and arbitration, I certainly have very fond memories of being a pupil of a leading maritime arbitrator whom I won't name, but I was told when I was told which venue we were going to, that I was told that we get a very good lunch there. So my experience of those days was much the same as was described, and indeed the informality that there was obviously a long time ago is I found absolutely fascinating. So David and Clive, thank you so much, and also thank you in a way as people who are basically arbitrators for having come into the lion's den to tell us about your various activities. What we're going to do is leave the meeting open if people just want to chat amongst themselves. But just before I do that, Dave, thank you for doing the first attendees. Dave, do you just want to say a couple of words about our and save the date for our next meeting?
Yes, thank you. Our next meeting is organised for Tuesday, the 11th of January. So it's a Tuesday as opposed to our normal Wednesday. The speaker is going to be Jane Gunn, who many of you will probably know. At that time, she's due to be the president of the CIR. And I'd also mention our December lunch. You should have hopefully had an email about that yesterday or early this morning. So if you can come along to that, that would be great.
Okay, thanks, Dave. Just before we kind of leave, since Martin is actually in Dubai at the Dubai Arbitration Week, Martin, is there any are there any a couple of words on any interesting developments on mediation in the UAE or in the broader region that you might like to make?
Yes, I've been here since Sunday, attending many of the Dubai Arbitration Week activities, events, etc. The vast majority of people I've spoken to say that mediation is on the up over here in the region. Very much more activity at the moment, and generally things are very brisk over here. Very busy. All the events that they've been organising here for Arbitration Week have been very well attended, and it looks more or less like business as normal now.
And I think you also mentioned when we were talking about this yesterday, Martin, that there is some talk about mandatory mediation in the UAE.
Yeah, as I understand it, that's going to be incorporated into the new DIAC rules, if it isn't already being dealt with at the moment.
Yeah.
But more on that, I'm sure, will be revealed.
Yeah, so DIAC, for everybody who doesn't know, people who don't know, is the Dubai International Arbitration Centre, which has recently kind of effectively taken over the other, what we might broadly call ADR institutions in Dubai. Okay, well, I think, unless Martin and Dave, I've forgotten.
Michael, Graham Perry's got his hand up.
Yeah, hello, Graham. Yeah, do you want to say something?
Yes, perhaps I should have chipped in earlier, Michael, but I suppose I wanted, and I am a person with a background in arbitration. In fact, I've been on panels with a panel with Clive, and I'm known to him. I'm also active in mediation, and my instinct is that there is really a much bigger difference between the mindset of an arbitrator and the mindset of a mediator. And to put, we always put the two items together under the heading of dispute resolution. But what is required of a capable, efficient, competent arbitrator, and what is required of a sensitive, open-minded, creative mediator, just seems to me the two very, very different sets of skills. I don't mean that a good arbitrator cannot become a good mediator, but actually they have more that separates them than unites them. And that the mindset of a mediator, in many ways you have to divest yourself of the organized, centralized thought process that arbitration has more in common with litigation than it does with mediation. And I think generally speaking, because we put the items together, link arbitration and mediation under the heading of dispute resolution, we suggest that they are linked by a common purpose and a common set of views and abilities. I don't. Increasingly, I come to the view that one of the big differences is the approach and the mindset and the thinking that is necessary for a mediator to get to a heart of a problem, whereas a competent arbitrator requires a different set of skills. I just want to mention that because I've thoroughly enjoyed listening to the presentations this morning. They've been extremely well organized, and I congratulate them both. And I say that because I think perhaps there is a difference between me and them about this issue, about what makes up the characters and qualities of a good mediator, as opposed to that which makes up the qualities of a good arbitrator. I just wanted to mention that point. Thank you.
David and Clive, do you want to maybe come back on that one? I have a few which I might share with everybody in a minute, but the first go.
Thank you, Michael, and thank you, Graham. I mean, you raised an interesting and important point. I think it's probably fair to say that not every good arbitrator would make a good mediator, and conversely, not every good mediator would necessarily make a good arbitrator. But there are a lot of people, of course, who are able to switch between those two mindsets. And you're right, it's a completely different process. What we're doing as arbitrators is we're evaluating the evidence and submissions before us and making a decision. And of course, that's exactly what a mediator is not doing unless they're specifically asked by the parties to do that. And even then, I think they should do it with caution. But for example, I can only really speak from my own experience. I practice as an arbitrator and a mediator, and I have a coaching accreditation, a business coaching accreditation as well. And I find that I switch from one mindset to another, depending on which of those functions I'm performing. Clive?
I think Graham is right. I think both of you are right in a sense. What I think perhaps covers the point is that when we started Lmaa mediation, about a third of our arbitrator members qualified as mediators. And I think that that's perhaps a fair reflection that certainly not all arbitrators have the right skill set to become mediators. Well, 1 in 3 might be about right, actually. But it's a good, valid point.
Yeah, I agree.
Well, Graham, thank you so much. That was a great point to round us off on. And again, thank you to David and Clive. And we look forward to seeing as many of you as possible on the 11th of January with the barefoot mediator, Jane Gunn, who will be by then the Presidente of the Chartered Institute of Arbitrators, and indeed just kicking off 11 days into her year. So Martin, if we leave the meeting open for a quarter of an hour, if people want to chat, I'm off to go and look at a boat. So that's a suitable maritime activity, I thought, to sign off with. So thank you very, very much, everybody. And again, many thanks to Clive and David. Bye.